Welcome to the final round of the 2022 HNBA 27th Uvaldo Herrera Moot Court competition. My name is Judge Leonardo Castro, and on behalf of the HNBA Judicial Division, I, along with my co-chair and director of this competition, Judge Betty Urban Capote, welcome you. Before I introduce our distinguished panel of judges and turn it over to the bailiff, I want to thank the HNBA leadership and staff for their unending support and the HNBA VIA Fund for their continued financial support of this competition. At the completion of the arguments, the judges will provide feedback to the students, and you are welcome to observe. And as a reminder, the awards ceremony will be held at 4 p.m. Eastern Time today. It is also being live streamed, and the link can be found at the HNBA website at the Moot Court portion of the website. Now, judging this final round of the 27th Uvaldo Herrera Moot Court competition are Judge Marco A. Hernandez, Chief Judge of the Oregon Federal District Court, Justice John D. Coriel, Justice of the Florida Supreme Court, and presiding over this argument is Judge Jimmy V. Reyna, Judge of the United States Court of Appeals for the Federal Circuit. We thank them for their time and their commitment to this very important program. And now I turn it over to your bailiff, Alan LaRoya, to open the session.
Thank you, Judge Castro. Oyez, oyez, oyez. The Supreme Court of the United States is now in session. The Honorable Chief Justice Reyna and Justices Coriel and Hernandez presiding.
Good morning. We have one case on the docket for argument this morning. James and Elizabeth Cannon as parents and next of friends of AC, and Thomas and Catherine Ortiz as parents and next friends of JO and TO petitioners versus Laura Williams in her official capacity as Commissioner of the Hamilton State Department of Education respondent. This is court case number 22-001. Are the petitioners ready to argue?
Yes.
Are the respondents ready to argue?
Yes, Your Honor.
Okay. I'm going to ask that each litigant, right before you start your argument for the first time, to state your name clearly. And one of the judges may ask for you to spell your name, just so that we get it correctly on our review of your arguments. The petitioners, I understand you set some time aside for rebuttal. Is that correct?
Yes.
And how much time did you settle on?
2 minutes.
2 minutes? Okay. All right. Well, I think we're all ready to go. So let's hear from the petitioners.
Chief Justice, Associate Justices, and may it please the court. My name is Ariana Bustos, and I represent the petitioners, the Cannons and Ortizes in this case. I will be arguing the free exercise issue, and my co-counsel, John Kagan, will argue the Establishment Clause and equal protection issues. Your Honors, in this case, the state of Hamilton is denying a generally available public tuition assistance program to religious families that choose to send their children to schools that follow their sincerely held religious beliefs. And this sort of restriction should be subject to strict scrutiny and violates the Free Exercise Clause. This court should reverse the 12th Circuit's decision for 3 primary reasons. First, because Hamilton is expressly denying a qualified religious entity a public benefit solely because of its religious character, which this court found in Trinity Lutheran Church was generally unconstitutional. Second, the 12th Circuit wrongly concluded that Hamilton's statute is use-based, not status-based, which this distinction has no basis in the Constitution. And third, the statute is based on animus. Moving on to my first point. Hamilton's statute expressly demands a school be non-sectarian, or it can't meet Hamilton's requirements for funding. So on its face, Hamilton's statute excludes those religious schools because—
Counsel, when you say on its face, point me to exactly the language that you're talking about.
Your Honor, the language is non-sectarian in accordance with the First Amendment. And by including this language, non-sectarian in accordance with the First Amendment, it naturally disqualifies qualified religious schools such as in this case that already qualify for private school education, that are great schools, but otherwise may have some religious teachings.
Well, what's the prohibition? What's the restriction?
The restriction here is that the families can't choose to send their children to these religious programs. And by being excluded from this generally available public benefit, it violates this the Constitution under this court's precedent. Very similar to this court's holding in
Aren't the
Espinoza.
parents choosing where they want the children to go to? Isn't it
Yes.
the parents that? So why is the statute restricted? It seems to me that the parents have a choice here.
Correct, Your Honor. The parents have their private choice to send their child to a school of their choosing. And the state of Hamilton, in this case, is providing this generally available public benefit, but conditioning it upon the fact that you can't send your child to a school that in our minds is too religious. And this conditioning.
But how do you distinguish what's happening here from what happened in the Locke case out of Washington, where Justice Rehnquist didn't see a problem?
Your Honor, the Locke case is different, and it should not apply here at all because Locke is distinguishable. In Locke, scholarship recipients were free to use the money at accredited religious and non-religious schools alike, but not permitted to use the funds to pursue a devotional theology degree. Now, regardless of what kind of education Hamilton students choose to pursue, they can't apply their public benefit at a religious school at all that follows their sincerely held religious belief. And the exclusion in Locke was also based on historic and substantial interest of prohibiting funds going directly to an essentially religious endeavor of training the clergy.
But isn't another way to look at it is that Justice Rehnquist was saying to the world that as long as states are applying these laws in somewhat of a neutral fashion, that the Supreme Court wasn't, and the law shouldn't interfere with what those states were doing. And in fact, in a later case, I think it was maybe the Lemon case or something like that, he came out the other way and said, you know, that wasn't okay for particular reasons, or it was okay. But again, Justice Rehnquist, I think, is really clear that as long as the states are kind of on their own in this area, we're not going to interfere.
Your Honor, the state is not really applying this in a neutral fashion. And the reason for that is because there will naturally be some difference under this program for certain religious families versus others. For instance, there are certain religions where a family must send their child to a school, like I believe Orthodox Jewish people must send their children usually to Orthodox Jewish schools, and they don't qualify under this program. While another family that doesn't have these sincere religious beliefs could qualify under this program, could get that aid. And under this court's precedent in Espinoza, in Trinity Lutheran, in Thomas, when there's this generally available program, you cannot pick and choose which religious families get to use the program and which religious families can't. And that's—
Can we talk about in what sense this program is generally available for a moment? Does the record tell us, or can you tell us, what makes Templar Academy sectarian while Bryant Christian School is not?
Your Honor, I believe that Hamilton sees Templar Academy and Bryant Christian School as both not sufficiently non-sectarian because of their biblically intertwined education. And what makes this generally available is that they've created this program where you can receive tuition aid, similar to that in Espinoza. You could receive scholarship funds, or similar to that in Zellman, where you could receive aid to send your child to a private school. But they're conditioning it upon the fact that, frankly, parent, if your private choice is to send your child to a school that follows your sincerely held religious beliefs, you can't send that child to that school. And that kind of condition goes against this court's precedent. It's both status and use-based discrimination. But frankly, use-based discrimination is also not allowed. Is also not.
Well, that's not correct, is it? I mean, there is case law that says that some use-based instruction or discrimination is permissible.
Yes, Your Honor. In Locke v. Davie, when it's an essentially religious endeavor that is historic and substantial, then it's okay. But that doesn't mean that every use-based restriction is okay. And in this case, it's not historic and substantial. And in fact, this court explicitly said in Espinoza that going back to the founding of our country, many schools that were religious were actually funded by the state. And it was only until the turn of the century that this changed. So it's not a historic and substantial interest. And in fact, this program itself in 1873, when it was first enacted, also included religious schools and only changed in 1980. Now, this kind of goes.
Didn't Espinoza actually reserve that question about use space?
Yes, Your Honor. Espinoza reserved that question. They explicitly refused to say whether a lesser degree of scrutiny applied. And now this question is up for this court today. And we'd like this court to hold that strict scrutiny does apply. And even if this court doesn't take away the statute based on the free exercise clause or based on the use-based discrimination or the status-based discrimination, Hamilton's statute impermissibly targets religious schools based on animus. And the reason for that is because a number of reasons. First, when this was enacted in 1873, they allowed all religious schools. Then in 1980, they switched because they were afraid of violating the Establishment Clause. And then later considered repealing their non-sectarian requirement and changed their reasoning, saying suddenly this is a free public education, which makes this reasoning odd. And in this case, while considering that repeal of the statute of this non-sectarian requirement, a legislator said that the Supreme Court rejected as unconstitutional publicly funded separate but equal schools where the education system funded separate schools based on race.
So where is the discrimination here on religious status? I fail to see it, and especially since you brought up the analogy of Orthodox Jews. There, you know what religion they are and what they practice, but I don't see anything in the statute that even mentions a denomination or a belief or anything.
Your Honor, you're correct. There isn't a specific factual.
Well, how can there be animus then?
Well, there can be animus based on these legislatures' comments where he likened separate but equal schools based on race to funding. And he said separate and sectarian schools where the educational system funds separate schools based on religion. And that's similar to Masterpiece Cake Shop, where a commissioner made a comparison of religious beliefs to those of slavery. Here,
but you're asking us then to find the animus in the legislative history of this rather than on the face of the statute. Is that your position?
Yes, Your Honor. So you can
so you're saying that there is no animus on the face of the statute?
Yes, Your Honor. I'm not arguing that there's animus on the face of the statute. I'm arguing it's status-based discrimination on its face, but not necessarily animus. Though paired with the legislative history, there is animus. This Hamilton legislator likening parents who want to send their children to schools that follow their sincerely held religious beliefs to segregationists is animus against.
Aren't you walking yourself into a strict scrutiny review?
1 minute remaining.
With this position you're taking? You can answer the question.
Yes, Your Honor. This is strict scrutiny. No matter what, we'd like this court to apply strict scrutiny. And this court can also choose to take down this statute based on animus. There are several ways this court.
Okay, that's fine. Let me see if my colleagues want to ask a question before you sit down. I'm going to keep your your reserved time. Okay, your minute. See, do my colleagues have a question?
My question has to go with that last point, and it sounds to me like what you're saying is that in the formulation of the statute, the legislator or whoever formulated it got it wrong because they were concerned about an establishment clause violation. And clearly it's not an establishment clause violation. But so what? So they got that wrong. Doesn't mean that the statute's wrong.
Your Honor, you're correct. And I can answer this question and then briefly conclude, correct?
Go ahead.
Go ahead.
All right. You are correct that each thing standing alone, the stray comments alone may not make this animus. The legislative history alone may not make this animus, but paired together, This court doesn't need clear evidence. It only needs a subtle departure. And this is a subtle departure of neutrality. It is animus. And so the 12th Circuit decision should be reversed. Thank you.
Thank you.
Justice Curiel? You're good? Okay.
Nothing further.
All right. Let's hear from the respondents and I'll restore the minute of the rebuttal time, Counsel.
Your Honor, may I proceed? I am the second petitioner,
Okay. Yes.
and my name is John Kagan. Would you like me to spell my last name?
Why don't you? Yes.
Kagan. Kagan. John Kagan.
Okay. Yeah, I see we have your name on the screen also. Okay. All right. You may proceed.
Thank you, Your Honor. Chief Justice, Associate Justices, and may it please the court. My name is John Kagan, and I represent the petitioner in this matter. We respectfully request that this court reverse the judgment of the 12th Circuit and find that Hamilton statute is unconstitutional. This is a case about religious discrimination, whether with good intentions or with bad intentions.
To what extent does Espinoza control the result in this case? It seems like you have a hard hill to climb.
Well, Your Honor, we disagree. We think Espinoza is exactly on point. In Espinoza, there was a Montana statute that said that there is going to be a generally available subsidy program, and it's going to benefit everybody except for sectarian schools. And that was written in the statute, just like it's written in the statute here. And it's written non-sectarian, but there it's the same thing. It's one or the other. And it says that you cannot give funding from the state, from Montana, directly to these sectarian schools. Espinoza analyzed that, and it said that you can't do that. You can't pick and choose. You can't discriminate based on whether or not a school is a Catholic school or a Christian school or what have you. You can't.
But there's a difference here because, again, Espinoza specifically reserved the use question. And in this case, there's no doubt that the schools are intending to use the money for religious purposes, for religious education and to promote their religions.
Your Honor, in some respect, as my co-counsel mentioned, there is kind of a false distinction between use and status, because how can you be religious as a status without also doing religious things? In Justice Gorsuch's concurrence, he said the right to be religious without the right to do religious things hardly amounts to a right at all. So this dividing line between
but let me interrupt you on that point, because if part of the religion, for example, is constructing the building where people are going to worship, is that a religious use?
Your Honor, in that case, that seems to be just a regular, doing something that does. I mean, if there could be religious parts of that might be sort of a devotional endeavor. And in that respect, it should be. But Your Honor, this is tricky. It's asking a lot of religious questions. And that's one of the problems with this statute, in that it's also a violation of the Establishment Clause. So, Your Honor,
don't the parties here self-identify what their affiliation is?
Your Honor, that's true. But in the record on page 17, Hamilton admits that it must make a determination in order to assess whether a school is properly sectarian or non-sectarian under the statute. Therefore, Hamilton must make an analysis or investigation. And that's problematic, because this court said in Lemon that an inspection.
Well, it doesn't, but they don't do that. They just simply are allowing the other, these entities to self-identify. I don't see that they're getting into any type of test or declarations that they from the parties.
No, Your Honor. On page 17, the record says that the commissioner, in situations of doubt, when it's not clear whether it's on its face. So, Your Honor, BCS and TA, I admit, on its face, they identify as sectarian schools. They're not hiding it, and neither should they. But there are closer cases than these two schools where a commissioner, Hamilton's commissioner, must go in and must make a quote and unquote determination as to whether that school is properly non-sectarian.
But I hardly think that's sufficient entanglement, governmental entanglement on the question. You haven't show me where the entanglement is.
Sure, Your Honor. In order for a school to receive funding under this general subsidy program, they must qualify as properly non-sectarian. How are they going to do that? Well, sometimes they identify as non-sectarian or sectarian, but if there's an issue of doubt, for example, if a school has a prayer at the beginning of class, but after everything else, after that, it's completely secular. All the curriculum is secular, all the teaching is secular, except they happen to have this traditional prayer. Well, that kind of toes the line between what is sectarian or non-sectarian. Hamilton has to make a determination, has to decide.
Okay, you're arguing degree here, and I just don't see the law being applied in this manner. You know, finding out if you only pray in the morning, you may be okay, but if you pray 3 times during the day, the classroom day, then you're not okay. I don't buy that argument about degrees.
Well, the question is not whether the answer is right or wrong. The problem is that they're asking these questions at all. And in Lemon, in Agostini, in Bullock, this court said multiple times that an inspection, an evaluation, and here a determination is an excessive entanglement between the state and religion. But Your Honor, there's multiple ways to find a violation of the Establishment Clause. Here, the statute serves to inhibit religion. And the way that it does this is it establishes a religion of secularism. This court said in School District of Abington that a state may not prioritize or prefer non-religion to religion. It may not show open hostility towards religion. And perhaps I could give you an example as to how that might work. So in Hamilton, somebody who might be anti-religious, like Richard Dawkins, a prominent atheist, he might say, I'm going to start a private school in Hamilton, and I'm going to teach a secular curriculum on math and science and the arts. But along the way, I'm going to make these comments. It's going to be totally through in my curriculum that everyone that believes in religion is a fool, that religious people are fooling themselves. And it's okay because it's non-sectarian. That's completely non-sectarian. And that illustrates the fact that Hamilton is preferring non-sectarianism to sectarianism. And that, this court said, Hamilton may not do. That is a violation of the Establishment Clause. But Your Honor, even if you do not agree that this is a violation of the Establishment Clause, this statute still fails because it is a violation of the Equal Protection Clause. And that is because Hamilton is treating religious families differently from non-religious families. Here, everyone in Hamilton is offered a choice. You get to send your child to the school of your choice. Hamilton will fund it, except if you want to send your child to religious schools. Who does that hurt? Who does that hurt?
Let's talk about the Lemon and versus Kurtzman case for a minute. Can you explain to me how your analysis fits in with that case?
Your Honor, I admit that Lemon had to do with the extension of state funding, and here this has to do with the prohibition of state funding. So I can see the distinction that is possibly arising here. But the principles of Lemon still apply. And it's the principles of Zellman, it's the principles of Agostini, it's the principles of Trinity Lutheran and Espinoza, in that if there is an official action that discriminates on religious grounds, the Establishment Clause is in play. How can you determine if you are discriminating on religious grounds? Use the 3 prongs of the Lemon test.
But in this case, there isn't any question because the schools themselves have admitted that they are religious schools. We don't have to delve into whether they're sectarian or not sectarian schools, correct?
No, Your Honor. In this case, the schools have admitted that they are sectarian schools. They have identified as sectarian schools, but there are many religious schools across the country who want to get students who can benefit from this program, and they may identify as non-sectarian, but the Hamilton commissioner may disagree and may say, I think that is a sectarian school, and it's disqualified from.
Does it matter if that question isn't in front of us right now? I mean, we have the case in front of us, and the case in front of us, that's not an issue. Why am I deciding a case that isn't in front of me?
Your Honor, because of who it affects. If this Hamilton statute is constitutional, it is enshrining a scheme where religious schools are treated differently than non-religious schools.
That may be true, but you're trying to insert a different set of facts here, or have us focus on a certain result. Let me ask you a question. So with Espinoza, the discrimination we have decided is based solely on religious status. as opposed to being based on use. What's the difference? What's going on here in this case with use and status?
Your Honor, I believe the distinction that the respondent would like you to make is that this Hamilton statute is only forbidding religious uses, and that the school is it's completely intertwined with the biblical program. And so therefore, when you send your child to that school, you are fundamentally doing a religious thing. You are making a religious use of that money. But that's not what's happening here. What's happening here is that schools are disqualified because of their religious uses, but religious use becomes religious status.
Well,
Who
but
does religious things?
to Justice Hernandez's question, though, addressing the record before us, we have statements from the parents saying that they made this educational choice because it squared with their worldview, right? That's in the record, right? So I guess my question for you, Mr. Kagan, is, aren't they in fact doing a religious thing by sending their children to these schools? Isn't it a purposeful religious act that they are making? And don't you sort of need to own that fact in the record?
Your Honor, I do own that fact in the record, and it's completely true that they are doing a religious thing. And there's that question perhaps is best answered with an equal protection analysis. And the issue here is that they are trying to do a religious thing, and they are not able to do that religious thing where everyone else is able to do it according to their conscience. So if I'm a lover of the arts and I want to send my child to an art school, Hamilton will fund that choice. If I love sports and I want to send my child to the best private sports school in Hamilton, Hamilton will fund that choice. But if I love my religion and I want to send my child to a religious school, Hamilton will not fund that choice. And so therefore, religious families must make a choice. They must either decide to comply with Hamilton's program and wince and send their child to their second choice school or their third choice school, or they must take advantage of the program, or they can deny the program and pay for it themselves. And the Ortizes, my clients, cannot afford to do that. And that is a big problem here, because this court has said that you cannot infringe upon a fundamental right to direct your child's education in Wisconsin v. Yoder, to direct your child's religious upbringing in Espinoza.
But you're saying that the court has said that, and the court has made some statements in that direction, but they've also made statements in the other direction. I mean, the Locke case is pretty clear about that.
Your Honor, the law is very clear about one thing, and I'm almost out of time. May I answer this question and briefly conclude?
Yeah, and you might have misheard me. I said the Locke case, not
Locke. Yes, Your Honor, we think that Locke is completely distinguishable because Locke had to do with funding a clergy. So that's a professional training. So in Locke, you could still go to that religious school, but you just couldn't do a religious thing at that religious school, a very specific religious thing, which is going to seminary. But you could still go to that religious school. You could even take seminary classes. You just couldn't get a seminary degree. So that is a very different thing. You can't even go to these religious schools at all. So Locke is completely distinguishable. But Your Honor, as I briefly conclude, this court has said that you cannot treat religious families differently than non-religious families. Religious families are the only group in Hamilton who have to subordinate their sincerely held beliefs in order to benefit from this program. Under Everson v. Board of Education, this court has said that a state may not deny a generally available subsidy program on the basis of religion. That is exactly what is happening here. That is a denial of equal protection that is unconstitutional, and this 12th Circuit ruling should be reversed. Thank you.
Okay, let's hear from the respondents.
Yes, thank you, Your Honor. Would you guys like me to spell out my last name, or can you see it from the screen?
We can see it already. You just may proceed.
Okay, thank you. Good afternoon, Mr. Chief Justice, Your Honors, and may it please the court. My name is Eddie Cervantes, and I, along with my co-counsel, Ms. Leah Levin, will be representing the respondent today, Ms. Laura Williams, in her official capacity as the Commissioner of Hamilton's Department of Education. My co-counsel will address the second issue, arguing that Hamilton's statute does not violate the Equal Protection Clause, and I will be addressing the first issue, arguing that Hamilton's statute does not violate the Free Exercise or Establishment Clause of the First Amendment. This court should affirm the ruling of the 12th Circuit Court for the two following reasons. First, Hamilton statute does not discriminate based on religious status. And second, Hamilton statute does not violate the Establishment Clause because it creates an appropriate boundary between religion and state. The 12th Circuit Court correctly held Hamilton's tuition aid program does not violate the First Amendment. Hamilton, through the language of the statute in 2951.
So can I interrupt you a second? Because one of the things that's really fundamental, and I don't want you to go too far before we get to this question, is how do we figure out what is sectarian, what isn't sectarian?
Yes, Your Honor. So Espinoza was not clear with a hardline rule that something is status-based as opposed to use-based. However, the issue at present, there is a clear line that
but my question is more fundamental than this. And I know that in this case, the schools themselves have identified themselves as religious. But it seems to me that for other schools, not ones that self-identify as religious, somebody can say, you know, my school is going to be called Martin Luther King School, and we are going to follow all of the tenets of the Reverend Martin Luther King Jr. And that means a whole bunch of things. And here's what the list is. Is that a religious school?
No, Your Honor. So there is also a fundamental distinction between religion and just an ideology. Either way, when there is a hard fundamental ideology integrated within the educational curriculum, such as Bryan Christian Academy and Temple Academy, they would not be able to receive the tuition aid because the legislative history was meant to create a public school system in lieu of creating their own and building up a public school system. The citizens of Hamilton have an SAU and do not have the option to go to a free public school system. And so Hamilton, with all these requirements in the statute in order to receive tuition aid, is creating a public school system. And just like any other public school system in the US, a public school system has to be neutral to ideologies and religion. Your Honor, to my first point, the statute does not infringe on the free exercise clause of the First Amendment, since it does not prohibit families from sending their students to a sectarian school, nor does it prohibit the families from exercising their religion. This is clearly exemplified on page 3 of the record. Although petitioner may argue that the families don't have a choice or they're being infringed because it's so fundamental to their religion that they go to these schools, one family of the petitioners has their son in a sectarian school and have a daughter in a non-sectarian school. The difference between here and a case like Lukimi Baba is that Hamilton is not imposing any civil or criminal fees because this family sends one student to a sectarian school and another to a non-sectarian school.
Mr. Cervantes, let's pause on that and think about the rule you're asking us to adopt. Are we then to say, and you want courts to be in the business of saying to parents, that if you make a different choice for each of your two children and choose one to go to a non-sectarian school and one to go to a sectarian school, then it doesn't really matter to you, or this isn't really an act that deserves the protection of strict scrutiny because you've elected that choice? I mean, that seems, I guess, this sort of backdoors into my real question, which is, shouldn't we be applying strict scrutiny to this?
Your Honor, we can apply strict scrutiny, and even with strict scrutiny, this Hamilton statute would satisfy it. And that's the argument my co-counsel will be making. To your first question, Your Honor, we don't want this court to say just because you have one child in a religious school and the rest of your children in a non-religious school, then the state is not violating your free exercise. We're merely stating that because of this example, that one family is able to send their children to a sectarian school and one one to a non-sectarian school, and that there is no civil or criminal liability, then their free exercise right is not violated because the Hamilton state is not coercing, prohibiting, or punishing them in any way.
But it's not our law, is it, that unless there is a civil or criminal penalty associated with an action, then it is not being burdened from a free exercise standpoint. Is it? Is that our law?
It's not, no, Your Honor, it's not precedent here and it's not black letter law. However, it is law that that a state cannot punish, prohibit, or coerce the free exercise of a religion when it comes to any family or any individual. And
right,
here,
but my question is, you seem to suggest that as long as the government refrains from imposing civil or criminal liability on an action, then it hasn't violated that rule. And that can't be the law, is it?
No, you're not, Your Honor, it's not necessarily the law. However, it is a clear example of how Hamilton is not putting any kind of burdens on families in exercising their free religion. If one of this family is able to send their student to a sectarian school, Hamilton is not infringing the right to do so.
Well, what are the choices here? Explain to me what are the choices that the parents have? They can send the kid to a private school or public school, right?
Not necessarily, Your Honor. So here in Hamilton, this school administrative unit does not have a public school system. So the options of the family is that.
Well, it's a private, they could send them to a private school, but that's non-sectarian.
Correct, Your Honor. So they have the option of sending their students to any of the private schools that satisfy the requirements laid out in statute 2951. However, within the statute, it says that the private schools must be non-sectarian in accordance with the First Amendment of the United States Constitution. This language in the inclusion of the statute adheres to the First Amendment on its face. Hamilton's non-sectarian requirement simply bars public funds from promoting.
But if a parent wants to send their child to a private religious school, that school will not be funded, or they won't do that because the school's not, they're not going to get the program benefits.
Your Honor, it depends on the religious institution. So because of the language in accordance with the First Amendment.
What do you mean it depends on the religious institution? What, the denomination?
No, Your Honor, it depends on how the funds are being used in the religious institution. For example, here on page 4 of the record, Bryan Christian Academy.
Does it really depend on how the funds are being used, or is it a question of whether they're used at all for religious purposes?
It's how the funds are being used, Your Honor. This is clear in Espinoza. Although they didn't make a clear distinction between status-based and use-based, they made the clear distinction that when state aid is prohibited by discriminating based on religious status, such as prohibiting a religious.
Where is it? Show me in the statute where it shows that the funds are to be used for religious purposes or non-religious.
Your Honor, in the statute, it says that it must be non-sectarian in accordance with the First Amendment of the United States Constitution. Currently, the First Amendment jurisprudence is that a state cannot discriminate based on religious status. In Espinoza, this court held that a religious—
5 minutes remaining.
It's discrimination based on religious status when a religious institution must divorce themselves from any religious affiliation, whether they're owned or controlled by a religious sect, church, or any kind of other religious institution. Here, Hamilton is not telling Bryan Christian Academy or Templar Academy to divorce themselves from whatever Christian church or sect or institution they're affiliated with. Merely, they do not want public funds to be promoting the indoctrination of their students. For example, Templar Academy, as noted on page 4 of the record.
Explain to me, what's your argument here? Are we talking about use or affiliation?
Use, Your Honor. We're stating that Hamilton's state tuition program only prohibits public funds to be used for religious activities. As I mentioned on page 4 of the record, Templar Academy has a biblically integrated curriculum. Therefore, any student that goes to Templar Academy will be receiving a religiously promoted agenda and be indoctrinated based on their religious views. Similarly, on page 4 of the record, Bryan Christian.
So, are you saying that in Espinoza that the schools that were in question weren't teaching religion?
No, Your Honor, but the statute in Espinoza said that they prohibit funds from any religious institution controlled or owned by a religious affiliated church, sect, or religious institution. Here, Hamilton is not making the distinction that a religious institution has to not be controlled by a church or sect or any other religious institution. It's merely holding that.
And so the problem is what it is that they're teaching is the problem with them getting the money. Is that correct?
Yes, Your Honor, that's correct. It's that Bryan Christian Academy has a biblically integrated education. Templar Academy also has a biblically integrated education system.
Is it your position that it would have been unconstitutional for the statute to have allowed the monies to go to the secular, the religious schools?
Your Honor, it would have violated the establishment clause here if it would have just given the money to any sort of sectarian schools. And that goes into my second argument, Your Honors. There is founding era evidence that show that this issue is not unique to our times. Our founding fathers were pretty clear on this answer. There should be no entanglement between the state and church. prior to the First Amendment, there was numerous state constitutions that did not allow any kind of government aid to go to any religious institution. In fact, Delaware's original constitution held that no man shall or ought be compelled to contribute to the erection or support of a religious institution. The existence of these provisions in state constitutions prior to the drafting of our nation's constitutions proves that the choice of a state to prohibit government aid.
Give me some recent cases where what you're saying is true, that money simply going to a school somehow has violated the establishment clause. Now, the free exercise thing, I think you have something to talk about, but tell me how giving money has now said that's establishing religions and so violates the First Amendment. What cases say that?
Sure, Your Honor. Lockheed versus David is a perfect example. There, this court held that state of Washington is able to not fund a religious endeavor such as receiving a theology degree. And that is because the students who wish to pursue a theology degree then go on to become ministers, clergymen, or any other influential position within a religious institution. And
yeah, but those were people, again, you're right. That was for people that were in fact going into the clergy. There's nothing about that in this particular instance.
Well, Your Honor, however, the same means to the end applies here. When students go to Bryan Christian Academy, or Bryan Christian School, I'm sorry, and Templar Academy, they are receiving an education that is biblically integrated. For example, on page 4 of the record, Bryan Christian Academy holds that the Bible is the final authority on all matters. So when these students go to Bryan Christian Academy, they come out knowing that the Bible is the final authority on everything, and anything contrary to that, they just do not hold as true. And therefore, when they go out into the world, and if they say, let's say they become legislators.
But then you run up against the Zellman problem, don't you? I mean, there was money going to Catholic schools there. They teach religion.
Your Honor, there are some distinguishing factors here from Zellman. In Zellman, there was a already public school institution in place. They were just failing public schools. And so what happened in Zellman is that the state decided to give vouchers in order for these parents to have the opportunity to send their students to a higher quality education, since the education they were providing has already been failing. And there, because it was just simply for students to be able to get a education, regardless whether it was religious or not, the state felt that there was no establishment clause or first free exercise clause because they was merely trying to supplement the already failing schools. Compare here in Hamilton, there are no schools. Hamilton simply wishes to—
The time has expired.
Your Honor, may I briefly answer your question and conclude?
Yes, go ahead.
Yeah, so here, Hamilton merely wishes to create its public schools by subsidizing tuition, and in doing so, creates a basic standards to mimic public school systems. And it's for these reasons, Your Honor, that this court should affirm the ruling of the 12th Circuit Court. Thank you.
Okay, thank you. Counsel Lewin.
Mr. Chief Justice, Your Honors, and may it please the court. My name is Leah Levin, and I too represent the respondents. Today, I will address the second issue and argue Hamilton's tuition program comports with the Equal Protection Clause. Your Honors, the 12th Circuit correctly held that Hamilton's tuition program does not violate the Equal Protection Clause for two reasons. First, Hamilton's tuition program must be subject to rational basis review because it does not infringe upon a fundamental right or invoke a suspect classification. Second, under rational basis review, Hamilton's tuition program is constitutional because it is rationally related to a legitimate government interest in providing a quality education while avoiding an establishment clause violation. To my first point, Your Honors,
Well, let me interrupt you for a second. If we disagree with you that there's regarding that there's any establishment clause violation, what does that do to your argument?
Your Honor, under any standard of review, Hamilton's tuition program should be upheld, and it will be found constitutional under the Equal Protection Clause inquiry.
But one of the things you said was, look, we were worried about this establishment clause violation, and I'm pretty certain that that is not the case. So take that part of your argument away. What's left?
The Equal Protection Clause, Your Honor, there is no violation of that challenge. Here, Hamilton's tuition program should be subject to rational basis review because it does not implicate a fundamental right or a suspect classification. Here, the petitioners erroneously allege that there is religious discrimination and that they're being denied a right to a public education. However, that is simply not the case. Here, Hamilton families are provided a choice, regardless of their faith. a choice to attend a non-sectarian school at the public's expense, or to attend a sectarian school at their own expense. Here, Hamilton's objective is clear, as indicated in the legislative comments during the legislative debate in 2003. Their objective is to provide tuition assistance programs to children who cannot receive a secular public education from their school administrative unit. And this benefit is applied both generally and equally to all Hamilton residents, regardless of their faith. Hamilton.
So who did, again, I'm going back to my original question that I asked co-counsel, and that is, who determines what's secular and what isn't secular? What are the, and simply telling me that it's ideology and secular are two different things, that doesn't answer my question. We need to know, in order to utilize the law that's being attacked in this case, what is secular and who decides?
Yes, Justice Hernandez. Well, looking at the tuition, the institutions that the petitioners wish to send their children to, we can look at the curriculum that they're being taught. And in this case, as reflected—
I want you to go beyond that. I don't want you to look at these institutions because they admitted that they're religious schools. Let's put that aside. How does, in other situations, and I brought up the example of somebody that goes to Martin Luther King Jr. School, as you know, there's certain tenets, and at what point does it become a religious school and therefore it's not eligible for money?
Certainly. In instances where the curriculum has completely integrated religious and biblical worldviews into their studies, that would certainly be considered a sectarian institution. Because in that instance—
Who decides that issue? Whether
Yes.
that integration issue that you just talked about. It's a commissioner, right?
Yes, Justice Reyna. The commissioner does assess whether a school curriculum is intertwined with its biblical worldview. However, that deep dive would be necessary for other standard compulsory educational requirements to assess whether—
Isn't the deep dive the entanglement that the Constitution prohibits?
Your Honor, there is certainly a degree of entanglement. However, the respondents are asking this court to look beyond the text before us and consider the bulk of cases.
Well, you use the term deep dive. Is that, I assume that's entanglement, a short dive or just a jump? That's not?
Justice Reyna, perhaps I misspoke and a short dive should have been more appropriate. However, the respondents agree there is a small level of entanglement here. However, we must look beyond that and assess the future implications of finding in favor of the petitioners. It's important to know that there are countless religions across the nation, more than 65. And within that scope, if the state is funding these religious institutions, that may lead to countless situations where these institutions are disputing with one another about religious favoritism, religious delineation. And so there is further more future implications of excessive entanglement if the state were to fund these schools, and thereby it would automatically be a state arbitrator within those disputes when these religious institutions are arguing with one another about what is considered too big of a space for a ministry or what is considered too small of a space. And so looking at the bulk of future cases, this court should find that the small level of entanglement here is appropriate in consideration of the excessive entanglement that invalidating this non-sectarian requirement may lead to.
Where is the dividing line then? You say the small amount of entanglement. What's a large amount of entanglement?
Your Honor, an excessive entanglement would be at the future implications of this case, where the state is acting as an arbitrator in litigation and being sued for perhaps discrimination on sexual orientation that these religious institutions are imposing upon its students. There may be an endless list of Title IX actions, again, involving the state because it is directly funding these religious institutions. And it's important to note that religious institutions are very sincere and strong in their beliefs, and they are openly discriminatory against LGBTQ students. And so again, that may lead to—
Where is that in the record?
Your Honor, may you please rephrase, what would you like me to indicate in the record?
Yeah, where's there any support in the record for the idea that these institutions are actively prejudiced against anyone?
Your Honor, you're correct. It is not indicated on the record. However, it is important to consider that is a possible future implication. It is also important to note that BCS and TA, as reflected on page 16 of the record, have yet to apply to be involved in this state tuition program, which may imply that they do not wish to seek this state funding. They are pushing back and do not want the state to be involved in their current affairs. Further, the appropriate standard here is rational basis review, because Hamilton's tuition program does not invoke a suspect classification because it does not.
Let's pause on that for a second.
Yes.
How is the invocation of sects not a clear signal that this is targeted toward religion, right? Sectarianism speaks only to faith, right?
Yes, Your Honor.
Okay, so how is that not a suspect classification? We're making a law that is expressly designed to speak to religion. How is that not suspect?
Yes, Your Honor. So traditionally, to obtain a suspect class status, a group must demonstrate that it has suffered a history of discrimination, that is politically powerless, and that faces discrimination
5 minutes remaining.
on the basis of an immutable, obvious, or visible characteristic. And so the Supreme Court has traditionally restricted 14th Amendments to discrete and insular minorities. However, there have been instances where religious discrimination has been warranted strict scrutiny challenges, but the context of those cases implicated a civil or criminal liability, such as in Church of Lucchini versus City of Hialeah, where the statute forbid religious killings because of an underlying criminal liability. And also in Christian Science Reading Room versus City of San Francisco, where tenants were unlawfully evicted or and their tenancy was unlawfully terminated, thereby involving a civil liability. And so in this case, there is no criminal or civil liability, and there is no invocation of a suspect class. Further, there is no implication of a fundamental right.
I'm not sure I follow how those two premises fit together. Let's say I agree with you that there's no civil or criminal penalty at issue in this case.
Yes.
On its face, this law, this ordinance, speaks to sects, and you've agreed with me that sects are exclusively religious, right? There's no such thing as a racial sect or a musical sect. We're talking about religion, aren't we?
Yes, Your Honor, we're talking about religion in this issue.
Then how is that not a suspect class? How are we not making a suspect classification?
Yes, Your Honor, in this instance, there is no suspect classification because we are not discriminating on the basis of religion. By contrast, the purpose of this program is to provide a public education. This is a very narrow case, applying to only.
What does the distinction then between sectarian and non-sectarian? How does that come in if we're not talking about religion at all?
Your Honor, it's important to look at the fundamental purpose of this program. In Espinoza versus Selman, it's distinguishable because those programs were choice programs. And so they were stating that parental choice must be upheld. And in those instances, if they wish to pursue a religious institution, they have the choice to do so. By contrast, we're looking at a default program.
Perhaps you didn't understand my question. And this is going off what Justice Correll was, I think, asking one. How is it that religion is not a suspect classification in this case when the statute makes its distinction between sectarian and non-sectarian?
Yes, Your Honor, there are certainly instances where religion is a suspect class and it deserves strict scrutiny, but that is not the case here because this program rides on the default of providing students with a public education that is equivalent to that which would have been in place had Hamilton had the resources.
Isn't sectarian and non-sectarian by definition a distinction in religion, religious affiliation?
Yes, Your Honor, certainly broadly there is a distinction. But again, here, the purpose of this program is not to provide parents with the choice to send their students to religious schools. By contrast, we are dealing with a small number of students in an isolated area where Hamilton has decided they do not have the resources to provide a public education. And so they're wishing to provide that education by sending students to the equivalent of a public education. And public education does not intertwine religion with its studies, as BCS and TA do, as reflected on page 3 and for the record, where their classes are limited to the extent of their beliefs and disbeliefs in certain theories. By contrast, Hamilton simply wishes to provide its students with a quality education in the absence of their ability to support and create its own public community. Moreover, in San Antonio Independent School versus Rodriguez, this court refused to hold that a public education qualifies as a fundamental right that warrants strict scrutiny.
1 minute remaining.
This court noted that not everything has to be perfectly provided, but requires that everyone receive a baseline education. Even if this court were to reverse its finding in Rodriguez, it would still not be subject to strict scrutiny in light of this court's decision in Reagan versus taxation without representation, where this court noted that a legislature's decision to not subsidize a fundamental right does not necessarily infringe that right, and therefore it is not subjected to strict scrutiny. Your Honors, under any basis of review, however, this program would be found constitutional because Hamilton has both a compelling interest in providing education and it also serves a legitimate interest. In McCollum versus Board of Education, as well as in Washington versus Yoder, this court noted that education is the apex of a compelling interest. And in this context, it is also narrowly tailored and rationally tailored because they are zeroing in on a small group of people that do not have a public secondary school available to them without this program. And so Hamilton wants to provide it to. Your Honor, may I briefly conclude?
Yes.
Thank
Go
you,
ahead.
Chief Justice. And so Hamilton, again, they're genuinely seeking simply to provide their students with the ability to receive a public education. In closing, this court should uphold the decision of the 12th Circuit Court of Appeals and find Hamilton's tuition program is constitutional. Thank you.
Okay. I think the petitioners have a rebuttal. And you had reserved a minute, is that correct, or 2 minutes?
2 minutes, Your Honor.
All right, I'm going to restore you to the 2 minutes.
Thank you, Your Honor. Your Honors, I have one overarching point. Respondents said this program was created in lieu of a public school system, and that like any other public school system, it must be neutral to ideologies and religion. However, Your Honors, this argument is an ad hoc reason that was only created after the state of Hamilton realized, under this court's precedent in Zellman, allowing this program to be administered across the board to all private schools, whether religious or non-religious, would not violate the Establishment Clause.
Was this argument made with the court below?
Your Honor, this argument, I don't believe it was addressed in the circuit court below, but it's an argument that we make under the legislative history of the Hamilton statute, which mimics the one that was made in Maine. Now, respondents' claim is that they don't want the children to be, in their own words, indoctrinated, but this is not indoctrination. It's a religious family choosing to send and raise their children as they choose. And this private choice breaks the connection between the state and these religious schools, as this court said in Zellman.
On the indoctrination point, I mean, the schools themselves talk about the curriculum, and it sounds, at least to me, as though what they are saying is, in fact, indoctrination into a certain worldview.
Your Honor, what makes the difference here is that if it's applied across the board, it essentially becomes the problem. As applied across the board, this would become the program in Zellman. And in Zellman, it was okay because that private choice severed the connection. And this isn't a public school education system. It's not public, and it's private schools. The state of Hamilton could have made a public program, but it did not. And therefore, the 12th Circuit decision should be reversed. Thank you.
Okay, we thank all the parties for their arguments, and this case will be taken under advisement, and this court now stands in recess. Bailiff, do you have your hammer?
The court is closed.
Okay. Let's have some comments, and I'll start. And you know, I say this every year when I have the honor of judging the moot court competition, but all of you guys are very good. You know, very good arguments. You did well, and on that basis, and as a past president of the HNBA, I thank you. I thank you for honoring us with your diligence, your intelligence, and your skills. Dick, a couple of things just spring to mind, and I don't have any precise, explicit comments to you individually. You want to listen to the questions that the court is asking, and when I say listen, it's that thing about listening but not hearing and hearing but not listening. There's another communication going on, and the judge is laying out what the problem is that they're having with your argument. And I think almost all of you were too quick to say, yes, Your Honor, you're right, and you dealt with our objection that's inherent in our question, or the problem that's inherent in our question. You deal with it by agreeing with us and then moving on, as if just the nature of the act of agreeing with us is going to satisfy us, but it doesn't. And oftentimes the court is going to drag you back, and say, no, wait a minute. And you do that. If you do that a couple of times, then you may be with an upset judge. So you want to listen carefully to the question and answer the question, other than just saying you're right. I heard that from some of you all for a number of times. Don't go too fast. And Leah, I think you were going a little bit too fast. I think down in Florida, you have some nice young judges with great hearing and stamina, but in DC, you got some guys like me who like things to go slow. I'm not a Texan, but I kind of act like one. I like things to go slow and easy, and so I ask you to do that, and pace yourself. You're making a presentation, so you're looking at the judge, and when you know that a judge can't hear you or didn't understand, you want to react to that. So a good way of doing that is by calling the judges by their name, and you may say something like, if I ask a question, you go, yes, Judge Reyna, the record does reflect, and then you go into that. And then you can segue your way out of there by saying, and as Justice Curiel brought up himself, or as Justice Hernandez inferred in this question, and then you get to move around that way. And it makes you familiar with the judge. It creates a certain familiarity there that is I think is important. Well, I'm going to stop here to give my colleagues an opportunity to also provide comments. But again, you all did a great job, and I look forward to seeing you in my court sometime.
Thank you, and thanks to the HNBA for having me and inviting me to participate. This is the first time that I've participated in this event. I think I graded papers one time, but this is the first time I've done the oral arguments. I really enjoyed it. I enjoyed listening and hearing from all of you. Again, I appreciate how hard you worked. I'm blown away at the level of professionalism and how prepared you were, how responsive you were to our questions. I thought this was not an easy panel. This was a pretty hot panel. We interrupted you when you're trying to answer questions, and that's always really tough. You didn't get to answer Judge Reyna's question because Judge Hernandez interrupted you. And I think that must carry with it some level of frustration. But I was just overall so impressed with all of you. And again, I'm a trial court judge. I'm not like Judge Reyna that is used to sitting in having people appear in front of him in the circuit court and is more familiar with this exercise. I have people do oral argument in front of me, but it is at the trial court level. And I will tell you that as compared to many of the trial court lawyers that appear in my courtroom, you were in some respects much better than some of the trial lawyers that I do. I think that this experience will be a really good one for you to carry forward as you go on into your legal careers. So thank you for that. As far as some comments, I know that there were some tough questions out there, and I think I tried to be familiar as I could in a short period of time with the cases. You obviously knew the cases better than I did. And it was never wrong for you to correct me, because I think one time I was citing the wrong case, and it's never wrong to say, Judge, you're not talking about that case, you're talking about this other one. That's always going to be okay in order for you to correct the judges if you do it kind of directly and in a way that maintains respect for the judge that you are in front of. But it is also really important that you answer the judge's question. You make sure that you have answered the question, even if it's an answer that you cannot live, that isn't comfortable for you. It's okay to recognize the weaknesses in your case and say, yeah, that's a problem for us. But this is why I think that even though that is a problem, why we can get around it. And some of you did a good job of saying, yeah, we recognize that case, but we're going to distinguish it in the following ways. And you all also did a good job in distinguishing cases that I was citing to you. I thought your familiarity with the case law that was out there was really impressive. I think it's really hard to remember the names of the cases. It's really hard to remember the specific facts. It's easy to get one case confused with the other. And I thought you all did a really good job kind of with your library of cases that you had in mind and having those in front of you and being able to respond to questions by citing the case law. I liked how all of you ended your statements to the court. Your wrap-up statements I thought were all really good. I would echo what Judge Reyna said, that some of you were kind of racing along a little bit, and that tends to happen because we're asking and firing questions, and you want to answer the questions but still get back to the point that you needed to make as well. And I think that's a very natural response to a panel of judges, in particular when the panel was as hot as this panel was, in as many questions as we asked, and really oftentimes not giving you an opportunity to respond to those questions. I think those are all of my comments. Again, I appreciate it. Sincerely, I'm just blown away at the quality of the oral argument that I heard today. So thank you very much for letting me be a part of it.
So each of you has a very promising future as an appellate advocate, if that's what you choose to do. You're all very facile and comfortable with holding in your mind disparate cases and fact patterns and understanding what cases hold and don't hold and what your best arguments are. You are all to be really congratulated. You're excellent advocates. I think Ms. Bustos and Mr. Kagan, maybe the best illustration of this in your argument was your use of Locke, which I think is probably the case that sort of best hedges the distinction between the sort of educational mission and the sort of formative, creation of advocates for a faith. Part of the issue with this moot court problem is that the case law happens to be a little bit of a soup. And you guys did a really, really good job of sort of navigating through the soup. And I think similarly, Mr. Cervantes and Ms. Levin, you guys did a really, really good job pushing back on me on the strict scrutiny sort of line of cases. And it demonstrated a real awareness of where the law is and where it isn't. So you're all really to be congratulated. I have very minor nits that I sort of noticed that I would pass along as advocacy pointers. One is the use of the phrase, my clients. Early in my legal career, it was drilled into me never to say those words, that consciously or unconsciously, and especially in front of a jury, the words remind people that you're there because somebody hired you, especially in a case where your clients are children and their next friends, parents, trying to vindicate their rights to an education, you should never say the words, my clients. You should say the words of their names. You should invoke them over and over again as their personal names, and not draw any attention to the fact that you're making any argument other than because it is true. And that is, to my second sort of nit, another sort of pet peeve of mine that you guys actually did a very good job navigating through, but you still did it a couple of times. I submit, I argue, we contend, we believe all of those are wastes of time and lessen the force of your advocacy. Just say it like it is. I know that you argue it. I know that you believe it. I know that you submit it. You're submitting it, you're arguing it, you're believing it, invites the reader or the listener to ask, well, not everybody does, right? Just say it. Just say what the rule of law is. Say what the position is without saying it's my position, Matt. Just saying this is the rule of law. That I always find more forceful and takes less time. But you're all really, really, really good advocates, and I look forward to seeing you before our court.
Thank you.
Thank you.
Thank you. And thanks to the
Thank
other
you.
side too. You guys were great.
Yeah,
You
thank
did well.
you.
It was a joy to oppose you.
Yeah, it was awesome.
Thank you. Good afternoon, everyone. I'm Judge Betty Capote-Urban, the Moot Court Director. I want to take a moment to thank you all for watching the final round of the 27th annual Uvaldo Herrera Moot Court competition. We've worked very hard for the last 4 days to get up to this point today. So we thank you for supporting our students, our judges, and the HNBA as a whole. I want to congratulate the finalists. As the justices stated, you did an amazing job. You should be very proud of yourselves to have made it here to the final round. It is not an easy accomplishment, and you had to go through a lot of teams to get through this point. So be very proud of yourselves. And of course, I'd like to thank our justices, Justice Coriel, Hernandez, and Reyna. Thank you so much. Your critiques today were invaluable. I'm sure the students will learn from that and apply that as they move into their legal careers, which I am sure after hearing arguments today will be very successful. We know the three of you are very busy, and thank you so much for taking the time out of your schedules to be part of this and to be part of this amazing moot court competition that we're able to put on every year for our students. I'd like to remind everybody once again that the awards ceremony will be at 4 o'clock Eastern Standard Time, and we hope to see all of you there. Thank you and have a wonderful afternoon. And justices, I remind you to stay with us in the room for scoring.